Hello everyone and welcome to this webinar on procurement and probity fundamentals. Before I commence, I'd like to acknowledge the traditional owners of the land on which I now am, the Whadjuk people, and to pay my respects to their elders, past, present and emerging. My name is Donna Charlesworth and I lead the public sector team in Perth at Clayton Utz. I advise both private and public sector clients in relation to tendering and procurement, construction and infrastructure projects. I'm very pleased to be co-presenting this webinar with Jamie Doran, who is our head of the National Practice Group for Public Sector at Clayton Utz. As a reminder, today's session is the first of three that the Clayton Utz's public sector team will be running. We hope you enjoy and join us on future briefings. The next one will be on data privacy and record keeping in the COVID-19 world. And the third one will be on reining in risk in government contracting. Jamie and I will be taking questions in the last 10 minutes of the webinar. You'll find a Q&A function at the bottom right-hand corner of your screen. So please send through your questions as we go through the presentation, and we'll endeavour to answer those at the end of the session. Thank you to those of you who've already submitted questions. If we don't get the opportunity to answer your question live, we will aim to address key feedback post this webinar. Please note that we will be recording this session and we'll circulate it in the coming days. The discussion today falls neatly into two parts that both address different aspects of the requirement for probity and integrity in the procurement process. Firstly, I'll be discussing WA's new Procurement Bill and how that new procurement framework is going to change the current existing procurement framework. One of the cornerstones of the new Procurement Bill is the introduction of much greater control over unlawful conduct. This reform to the public sector procurement is part of the government's response to a greater need for probity, highlighted by several recent major cases of corruption in government procurement. Jamie will then discuss exactly what is probity and why is it important, what are the risks, and he'll then give some practical tips about how to probity proof the process. The Procurement Bill was introduced into WA Parliament in June this year. It aims to provide a streamlined and effective government procurement framework. It's also part of an initiative from the government to support the state's economic recovery post-COVID. It's had its third reading in the Legislative Council and government is now seeking submissions just in relation to the debarment regime, which are required to be submitted by the 27th of June this year. Upon enactment, the new procurement framework will change the way that state agencies procure goods, services and work. So it's important to understand how that will implicate your procurement activities. The new Act will replace the current State Supply Commission Act, and there's been a lot of discussion and reports identifying the issues with that current framework. The problems were highlighted in 2017 in the Service Priority Review and again in 2018 with the Special Inquiry into Government Programs and Projects, and most recently, of course, in relation to the CCC report. These reports have all identified that the issues with the current framework are that it's complex, fragmented and inefficient. A major part of that inefficiency and complexity is that the current procurement system doesn't apply to construction works procurement and it's decentralised, meaning that you can have one supplier providing the same services and goods to multiple state agencies and yet being subject to different tendering conditions, different contracts and different contract management approaches. So the need for the change to the procurement framework has been one of the McGowan government's main key priorities. The COVID-19 pandemic has made this change a matter of urgency for the government, which is hoping to introduce the framework to give more flexibility into the procurement process and to allow government to be more responsive to events such as the pandemic. So how will the new framework improve procurement? The bill proposes a whole of government procurement policy. It will endeavour to try and generate efficiencies by applying that whole of government procurement process across agencies. It endeavours to make it easier for businesses to understand and engage with supply opportunities. It's one of the objectives of the new bill is that it's hoped that it will result in a minimisation of tenderers' costs, in the costs of tendering. A key change, of course, is that procurement is not limited to goods and services. It now also includes works and commercial leasing, which was one of the issues noted in problems with the past framework. I'd like to now discuss 4 key features of the bill that I'd like to draw your attention to. The first key feature is in relation to procurement directions. This is a new mechanism for state government to implement policy measures by issuing procurement directions about how state agencies are to administer and to comply with the new legislation. Procurement directions can either be general and applicable to all types of procurement and all state agencies, or the government has the flexibility to give a procurement direction just to a particular agency. The mechanism is intended to give greater centralised control over government procurement, which of course is a reaction to the agencies having more independence over their procurement activities. Interestingly, the legislation as it's currently drafted provides that a decision made or a contract entered into is not invalid only because a state agency or other person has contravened a procurement direction. The second key feature I'd like to discuss is that of audit and investigation powers. The legislation requires the Department of Finance to establish a program for the audit and investigation of procurement activities of state agencies. What this means is that the department will audit agency buying, collect and report on information, and address supplier complaints that cannot be resolved by agencies. The anticipated outcome of these greater audit and investigation powers is that government will be able to identify probity deficiencies across agencies and to be able to identify anomalies across agencies as well. The third key feature I'd like to talk about is that of cooperative arrangements. This allows agencies to enter into cooperative procurement arrangements established by another agency. This will streamline arrangements and allow opportunities, for example, for collaboration with local governments or universities. This is going to overcome a previous limitation of the current framework, which prevents other agencies establishing common use arrangements with other suppliers. And finally, the fourth key feature I'd like to talk about is probably the most controversial one. That is a new mechanism for supplier debarment or suspension. And this provides that a supplier may either be debarred or suspended from government procurement. As I mentioned earlier, public submission has been requested as to the detail of how this debarment mechanism will work. The conduct that might be grounds for debarment will be set out in the regulations that are yet to be released, but it's likely to include offences relating to fraud and corruption, industrial relations issues such as failure to comply with the Fair Work Act or the Occupational Health and Safety Act, environmental offences, and the non-payment of taxes. It's anticipated that there will be a right for aggrieved suppliers to apply to the State Administrative Tribunal for review of a decision to debar or to suspend a supplier from government procurement. I'd like to now hand over to Jamie to discuss probity and how to maintain probity in your procurement.
Thanks, Donna. Lovely to be with everyone today, and thank you for the opportunity. Greetings I'm based in Brisbane, sunny Brisbane today, so I wish good tidings on all in the West. I'll make two observations just quickly about the new Procurement Bill, because I've done a lot of procurement work across jurisdictions nationally. And my observation is this. Where you've got the jurisdictions that have, I'll call it the more prescriptive procurement regimes, those which are based like the Commonwealth around the Commonwealth procurement rules, or in the Northern Territory where you've got a similar regime to what Western Australia is proposing with specific directions. One thing that happens, and it's a bit like a double-edged sword, the certainty of the process, the certainty of the expectation, the legitimate expectation, to use an admin law term, of the market is increased. And so you necessarily have a greater focus on the way in which your procurement processes are now to be conducted. If you like, everyone's got the rule book and everyone will watch you and make sure that you are playing by the rule book. And that draws the spotlight to these issues of probity, which I'll talk about in a minute. The other thing I just wanted to observe is that I think nationally we're going through a renaissance, and it happens. You know, any students of public accountability will know the peaks and troughs of focus on public sector behaviour. We're going through a period of heightened focus on public sector behaviour. Everyone's seen the media. You know, we've got 3 procurement officers from the Department of Finance and the Commonwealth under investigation for their role and behaviour in a procurement process and their relationship with suppliers. We've had numerous issues in Queensland. I could do a whole day session about procurement issues that have arisen and probity issues that have arisen with public officers in Queensland. So I think generally when you talk about all public processes at the moment, probity is a focus. And it's an opportune time for us to just take a breath, remind ourselves of the key principles, remind ourselves of the key risks, because oftentimes we push probity into almost like a ticker box admin exercise. You know, have you got a probity briefing for that? Yep, all right, play on, let's move on. We don't actually stop and think about, well, so what? What happens if we get this wrong? What's the rubber on the road for the government if we find that we haven't or we've breached probity in the process? So as I said, I think it's an opportune time for us to talk about those principles, which I'm going to go through at a fairly high level today, but then also just reflect upon how those principles will operate in the context of this new procurement regime that we're bringing in. I'll start at the beginning. You know, the definition of probity, much used word, very much misunderstood. In fact, most people probably don't even know what it means. The etymology of the word, I always love going, I'm a bit of a student of words, I love going back to the etymology of words, and probity descends from the Latin, meaning probus, which is good, upright, or honest. If you look at the Macquarie Dictionary, you know, the modern interpretation is integrity and honesty, which starts to give it, you know, more of an understood meaning in a public sector context. And for us in a public sector context, probity effectively means that our actions and decisions in public processes need to be made lawfully, with fairness and honesty. All right, you can read numerous textbooks and you'll get combinations and permutations of that sort of definition, but effectively that's what this concept of probity comes back to, a concept of lawfulness, fairness and honesty. So you sit there and you go, well, okay, Jamie, how do we do that? All right, and I'll do the accounting trick. I'm not criticising the accountants who do a lot of the probity training. They're very good, don't get me wrong. But, you know, oftentimes this is where probity training gets to. You throw up a slide and you say, well, this is how you do it. And they're right. These are the things you do. You perform your duties impartially, uninfluenced by the receipt of threats, reprimands or rewards. You don't accept gifts or favours from other people. You don't entertain approaches from suppliers. You ensure your private interests don't conflict. You maintain confidentiality. You maintain accountability, and you follow the directions, systems and processes to ensure that everyone gets treated fairly. You pick up your clothes off the floor, as I like to refer to it as. I got a 16-year-old daughter, Molly, who she's lovely, beautiful girl, but just won't pick up her clothes off the floor. And I had a moment the other day where I said, look, I must be doing something wrong. You know, every parent sort of goes through this period of, you know, it must be me, not you. So I sat her down and I sort of thought, well, if she doesn't understand why picking up the clothes off the floor is important, then how can I expect her to comply? So I sat down and I literally went through. I said, Molly, it's not about the clothes necessarily. It's about respect for yourself, respect for the house, respect for your mum. It's about discipline. I should have got an award. Parenting 101, probably nationally, I should be put up as Father of the Year. Listening to myself, then one of those out-of-body experiences, looking at myself. Next morning, I come past Molly's room. What do you think? Okay, there was clothes everywhere, but you sort of get my point. If you're expecting people to get this, you need to go further than just the list, right? Because we've got the lists. The checkerbox lists have been there forever, yet we still have probity problems. So something's going missing. And I think it's this. I think it's this slide. People don't get the risk. People don't actually pause and say, so what? What happens if we get probity wrong? And I've tried to bucket it into 4 key categories, and each of these are fairly detailed, but for the purposes of today, we can skim across the nature of the risks that fall into each bucket. Personal risks. What's going on down in Canberra with these 3 individuals? Being reviewed. So you get it wrong, you're in breach of your obligations to comply with the relevant policies of government. So you've got potentially an employment investigation. You might have some form of sanction in terms of that. At the worst case, you might be investigated and you might be prosecuted. So these behavioural expectations, that's what they are. The way we undertake the process, our behaviour in undertaking the process, exposes us as individuals in the process to potential personal risk. So we need to get this. I'm vehement with all of my clients. I'm passionately self-interested in you. I want people to understand probity risk primarily to protect themselves, because I've seen too much over the past 3-5 years where we've got the crime and corruption investigations going on across jurisdictions to individuals who've crossed the line of probity. There's then on the right-hand side practical risks, and you know those better than I. When you're running a procurement process, what's one of the key things that we never have enough of? Time. If you get probity issues being raised by participants in the process, you're going to be delayed. There's going to be briefs that have to be put up the chain. There might be embarrassment. There might be, papers, newspaper articles, political embarrassment, ministerial embarrassment, a lot of pain and suffering in the practical world that you work in. At the bottom, there's risks of review of our decisions. Now, depending on which jurisdiction you're in, and WA is no exception, people aggrieved by decisions of government made during public processes may have a right to have those decisions reviewed. Now, your bill provides, as Donna pointed out, a particular merits review avenue for the debarment regime, but there may be other avenues of review, whether it be judicial review, in regard to other decisions made in the course of a procurement which might be inconsistent with the directions. It may not invalidate the decision because the legislation tries to cover that off, but there may be other avenues and there may be other risks in terms of a review of that decision that you need to take account of. And then finally, up in the left-hand quadrant, there is the private law risks. All right, it's well established in Australia that participants who participate in a public tender process have certain private law rights. Since the Hughes case, over 20 years ago now, there's been arguments that participating in a public tender process may create a process contract between the participants. So there might be rights for breach of contract. There might be representation type claims. A claim in estoppel where there's been a representation made, detrimentally relied on by a participant. They may well have a claim against the government in estoppel. Or there might be negligent misrepresentations made in certain instances. And then, for our more trade and commerce-like activities, we may even have a Section 18 of the Competition and Consumer Act type exposure, a misleading and deceptive conduct type claim. So there's a broad church of private law liability that we may have which arises out of breaches of probity. So how do we probity proof the process? Now that we've got a better appreciation that this is just not a tick-a-box admin exercise, what steps should we be taking to probity proof our processes? And I've tried to sort of pick out today, the big ticket issues that have come across from my 20 plus years of experience in advising on this. First thing that I find that is common to any probity issues is the absence of a clear plan. And it sounds trite, but the better planned a procurement, the much better it is to be protected from probity issues. And I say at the top, plan the process, don't just have a probity plan, because too often I think we just grab the template probity plan, which has, the 6 or 7 headings, which are pretty common to everyone who's ever sat through a probity briefing, with a bit of word underneath, and we print it off and hand it around to the team and go, there we go, probity's sorted. That's scratching the surface. Really, key probity risks come from an absence of understanding what it is that you want to do in terms of the process. So fundamentally, have we thought about the way that we're going to manage this process? Is it going to have an express and an interest phase? Are we then going to call for tenders? Are we going to want to do some engagement with the tenderers during the process? Have we been clear about the basis on which we're going to do that? Who are the participants? Are there risks about the information that they've got? All of that needs to be put into the probity plan or the process plan. And it relies upon, that third element, undertaking a key risks and mitigation strategies exercise. We do it for the contract. Everyone's really good at sitting there and going, oh, what can go wrong with the contract? Oh, yeah, we need this clause in the contract. We need this. And yet we're running this process where Rome can burn potentially, because we've not put enough effort into understanding the risks of the process itself. Training is key. I'm a huge advocate of making sure that people in the team, the procurement teams, understand what they're doing. It's no good just to give them a piece of paper, say, read it on your bike. We don't do that in hardly any other sector. So why do we do it when we're dealing with probity? You need to get people understanding the significance of their behaviour and what they need to be conscious of doing and not doing. And that in a training environment is a much better way of making sure that ensuring that they comply, rather than just hoping that they've read the documents and understood them. And then finally, if you've got a particularly significant procurement, or it's going to be risky because of the nature of what it is, how public it is, the amount of money involved, the types of people who are going to be participating, you need to ask, do I need help? All right, and probity it's a skill. There are advisors who specialise in giving probity advice. There's also people who specialise in coming along after the event and giving you a gold stamp as to whether your process has passed muster in relation to probity principles. The two roles are different. I often see documentation and it sort of schizophrenically talks about probity advisors and probity auditors. The two roles are different. Probity advisors help with setting up the process, advising on issues as you go through the process, reviewing your documentation, assisting to manage problems. The probity auditor doesn't. The probity auditor comes in at the end, looks at what's happened, and either gives you a report that says, yep, we're good to go, I don't see any probity issues or probity concerns or risks, or I do see that there's some issues here that present a probity risk. You can't do both. Your probity advisor can't give you an audit report. Right, the auditor can't give you advice during the process. That's a bit like Caesar judging Caesar. It'd be like me giving you a legal advice and then coming along after the event and going, oh, I've read Jamie's legal advice and it's fantastic. Well done. So be careful in terms of, if you need help, what sort of help do I need? And then, am I properly engaging with the right person for the type of help that I need? So the fundamental part of the tender process, or the place where a lot of our probity controls are managed, are in our tender conditions. And really the tender conditions have taken on a much more significant role since the Hughes case that I mentioned, where it was acknowledged that we can fall into these contractual relationships in the way that we engage with people during these procurement processes. And so if you want to look at your tender conditions, you can look at them through the lens of, this is my contract for the process. Now, you'll know how much effort and review goes into the contract proper, the terms and conditions on which services or goods might be supplied. We pore over that sort of stuff at times. We don't pay as much attention to our tender conditions. In fact, most of the time we just grab what the last ones were, or whatever we can find, and say, right, they're the tender conditions. Don't. Use your tender conditions as one of your key risk mitigation tools. Look at it through the lens of, it's my contract with the people who are participating in this process. And by virtue of that, you need to make sure that it has the clear rules of and for participation. You need to check that it aligns with any legal or policy requirements. So when the procurement directions come out, we'll need to ensure that whatever we're putting in our tender documents, however we're structuring our processes, it aligns and complies with our procurement directions. And then we're going to ask the question, all right, what sort of flexibilities do we necessarily need? And the typical flexibilities are what I refer to here on the slide as sort of the privilege clauses. Do I want to reserve the right to be able to not proceed, change the requirement if I need to, receive late bids, etc., etc., etc. And each one of those sort of has a little bit of case law that runs along with it. If anyone's interested, more than happy to do a more detailed session. But they are effectively telling the participants, I want to maintain as an agency flexibility in the way that I'll do this. And you need to come into this process accepting that. All right? It takes away the arguments that people say they have been treated in a way that they didn't expect. All right? They had a legitimate expectation, again, using the sort of admin law expectation, the old language of the admin law. I came in with an expectation you were going to do things in a particular way. You didn't. Therefore, I've either got a right of review, or alternatively, I've got some form of contract claim in breach, or I've got a representation claim against you. And then the final element of your conditions, you're always thinking about what sort of limit on liability. Like any contract, if I'm carrying risk, how do I deal with the risk or the liability risk as between myself and the participants? Do I want an exclusion of liability or a limitation on liability type clause? A lot of people ask me this question about, should our tender conditions, should they make clear that we don't intend to form a tender process contract? All right, that's a very common question. My view of it is it doesn't matter really. If your conditions are right and you've got the flexibility in there that you need, then the fact that it takes effect as a tender process contract doesn't really matter. But the problem is only a problem if we haven't got our conditions right, if we haven't sorted our process, if we haven't understood what are we going to do, what do we want to be able to do, what flexibilities do we want to retain. Only becomes a problem then. So keep that in mind. Make sure you check your conditions before they go out to the market and that you are satisfied that they properly and accurately represent the way you want to conduct your process. Key issue coming up from a probity perspective, conflicts of interest, probably the biggest ticket issue nationally in procurement processes. And problematic for the public sector. You've probably all done conflicts training, so I won't harp on it. The standard is different for the public sector than it is to the private sector. We don't have the material financial interest standard that the private sector operates on. So generally in the private sector, if you don't have a material financial interest in the outcome, you're fine. Public sector, our test is different. Our test is there a reasonable appearance of conflict? Is it reasonable for someone else to think that my judgment might be biased, compromised or partial? Okay. Normal business relationships, normal day-to-day relationships with proponents. You might be a contract manager. You've managed the contract for a couple of years. You're invited to sit on a tender evaluation team. One of the people who you've been managing is a proponent in the process. You're asked the question, do you have a conflict of interest? Strictly, you don't. If all you have is a relationship which has been confined to your day-to-day business activities, then no conflict of interest. Your public interest or your duty as a public servant isn't conflicting with your personal interests, which is the nature of a conflict of interest. Right? But again, I always say to people, if you've been in that situation, if you've been the contract manager of a proponent for a couple of years and you do necessarily know the individuals quite well, declare it anyway. Because there's no harm in declaring a conflict of interest. And I'll come to that on the next slide in a minute. Be careful with coffee. All right, all the time I'm sort of doing training around the country on conflicts. And inevitably, people always ask the question, but I just catch up with the suppliers occasionally and I'll have a coffee. I'll be the bad guy, I'll break the news to everyone. They don't like you. They're not catching up because they enjoy your company. Generally, suppliers catch up with contacts in department agencies because they want something. And ultimately, they either want information or they want favour. All right, so you be a bit cynical towards the catch-up with coffees. If it's not necessary, think whether you need to do it. And particularly as you get more senior in the agency, in the organisation, the much more difficult it becomes to have the regular catch-up coffees with suppliers who you know are going to participate in procurement processes. Much better that you start to remove yourself from those sort of things, and if you are to participate in engagements, that it's done in a more semi-formal way, perhaps with someone else in attendance, perhaps as part of a semi-organised industry engagement regime that the agency might set up. Security of information is the other risk that we're seeing from a probity perspective, which is quite common. Many instances of information, particularly now that we're all on electronic environments, sharing information which is confidential of one tenderer in a process with another tenderer obviously is a breach of probity. There's implied obligations or implied duties of confidentiality in participating in tender processes. Don't get caught by saying, well, the document didn't have confidential stamped on the top of the document. All right, the stamping of the document as being confidential or otherwise doesn't really make it confidential or otherwise. A document, so far as it's not in the public domain and it's been given to you where it is reasonable to assume that the other party thought you were going to keep it confidential, generally there will be an obligation, an equitable obligation of confidence that's been established. So my tip, assume anything you get in the tender processes from tenderers is confidential, and you need to make sure that it's not shared. Careful with email. I had a terrible example the other day. A tender evaluation panel was established. The procurement manager got the documents in to evaluate, had set up 2 email lists. One was called tenderers, one was called tender evaluation panel. Started to type in tender evaluation panel, but the auto load into email or into Outlook put tenderers, and so the person proceeded to send all of the tender responses to all of the tenderers, which was a pretty dire situation for that individual. So really take care with email. A great technology, but dangerous in terms of security of information. And obviously take care with your consultants. The government sector, private sector, we do a lot with consultants now. We don't know where consultants are going to end up eventually, particularly in areas where there's limited subject matter expertise. So if you are engaging consultants as an agency for the purposes of assisting in preliminaries to development of specifications or things that you know are going to be used in future tender processes, think about how you manage their engagement at that point in time. Now, it might be that you need to quarantine the individuals who are working for the department or agency to say, look, we've got an agreement that they're not going to participate in future processes. Or it might be that you say, look, we want an exclusivity arrangement. If the engagement's that significant, the agency might say, well, you're on our side. You can't pop up as part of a consortium bid down the track. But you need to take care with consultants to make sure that you continue to secure that information. Why? Because control of communications and control of information is a pillar of probity during a tender process. The principle is that any information communicated to one participant should be communicated to all participants. Why? Because all participants should be treated fairly in the process. It doesn't mean that everyone needs to be made competitively equal. So oftentimes I'm asked the question, well, you know, we've got an incumbent supplier. What do we do with them? Can they even participate? Because they know stuff about our business. No, you can't punish a supplier for good competitive knowledge. Now that is their competitive advantage. They should be able to use that in the tender process. What we're talking about is information that is necessary for the purpose of providing a response to the bid. And it's that information that you need to ensure is equally made available to all participants so that everyone has a fair opportunity to participate in the process. Careful with things like site visits and briefings. You know, oftentimes people are caught up with someone gave a site briefing and they came on site. We didn't offer it to everyone else. And is there a problem? Yes, if everyone hasn't been given the same opportunity. Establish registers of contacts with participants. All right, if you are engaging with them, if you are communicating with them, you know, to ensure that you can defend the argument or the claim that one participant's been treated in a way that's to their advantage over the other participants. Having a register of the contact to point to people or to be able to prove, no, that didn't happen. I know, I spoke to them at this particular stage. We didn't do that. No, that never happened. It's really important from an evidential perspective that you've got those details. Try and filter your communications through an individual or a single point of contact. Suppliers are great in government. You know, they'll pick us off. They contact one person and then they oh, sorry, no, I've got to go through Jenny. Do I? All right, well, I'll call another person and suddenly, you know, the message goes, I just spoke to Bill. Yeah, no, he spoke to Jenny. Yeah, he said it was okay to call you. So can you make sure everyone understands that for those communication purposes during a process, single point of contact, try and make sure that it's as controlled as possible. Avoid text during tender processes. I've had 6 or 7 claims, cases recently where texts are at the heart of probity breaches. Don't do it. Don't tell your team, don't be texting. And obviously be very, very careful of evaluation clarifications. And I've put some notes just on the slide there as reminders for those. The evaluation process itself, a real risk exposure area during a tender process or during a procurement process. The rules of evaluation aren't intuitive. There's probably a lot of engineers on the call today. I'm going to offend the engineers. I find, and I have found over many years, engineers struggle the most with evaluation. Why? Because they want to solve a problem and they're great at doing it. And so frequently the bids will come in or the responses will come in and the engineers will need to go, I know the one that's the best solution. And so we'll try and select that one. That's not what we do in a public procurement process. We have to look at the evaluation through the lens of the criteria. And the responses need to be assessed objectively against the criteria. If we got the criteria wrong, that's too bad, so sad. All right, we've got to go back and possibly start the process again if we got the criteria wrong. If the criteria is set though, the evaluation has to be done in accordance with the criteria. We can't put on the other hat and just start trying to figure out what the best solution is and disregard the criteria as part of the evaluation process. Again, if it's difficult, if you're not sure and you're worried about the implications, get some probity advice. Get someone else to give you an objective view of what your obligations are in relation to the assessment or the evaluation, and that will improve your defensibility. I think this is the final tip for probity, and it sort of goes to the heart, or probity proofing your process. It goes to the heart of the accountability obligation, which we all carry as people who work in the public sector. And that is, we have to be able to demonstrate how we have applied the public money. And this process that we have designed, that we have set up, is the process through which the application of that public money will be made. So we need the records. Accountability is effectively having the evidence to show or to prove what you have done. So keeping a paper trail during a tender process or during a procurement process is absolutely critical, particularly around these points. Record the conflicts of interest and the actions taken. Don't have a situation where someone's declared a conflict and you've still got a record of the declaration on your file, but no record of what was done, whether it was considered, whether it was determined as low risk, whether you told the person that they could or they couldn't participate. Make sure that you have a clear record of what occurred in response to that disclosure. The evaluation sheets, including your criteria and weightings, the evidence of how you got to where you got to in terms of your evaluation, file notes of conversations, minutes of meetings, all clarification questions and answers, all right, should be kept clearly on the file, and a record of any decisions or recommendations that the tender evaluation team might make to the relevant delegate. I'll put the last one in as a catch-all. Look, anything that can be documented during the process from an accountability perspective is worth getting documented and on the file. Memories fade very, very quickly. And particularly as we move into this environment where there's going to be more focus on the rules that we have to follow in doing these procurements, you want the evidential record to be able to protect yourself and your agency to show that you have followed the proper process.
Thanks, Jamie. We now have time. That concludes the formal part of the presentation. We've now got time and would like to invite you to submit questions in the chat section at the bottom lower hand right of your screen. So please do send in your questions. If you do have any agency specific questions or something that you don't want to deal with in the chat, don't hesitate to contact Jamie and I after the webinar. For the moment though, let's start. Some people have sent through questions in advance. We have received the following question on probity, Jamie, which I'll ask you to respond to. The question is, any suggestions for maintaining healthy probity practices as procurement professionals, however, still having an open dialogue with the vendor community and early engagement before the formal procurement process on possible market activities? Is it even possible?
Yes, it's possible and I think necessary. We went, 15, 20 years ago in response to the Hughes case. I think there was a lot of training or advice that went out that, engagement with the market must stop because of this probity risk, and we left it at that. We sort of called it a probity risk, and everyone shouldn't make contact with suppliers before a tender process is undertaken. I think that position has been debunked now, and most jurisdictions around Australia recognise that to get the best outcome from these procurement processes, agencies need to maintain some level of market intelligence and dialogue to understand what suppliers can do, to understand what's feasible in the marketplace, to be able to benchmark. That's all included within what is an expectation of market analysis or the market analysis phase of procurement processes in lots of the jurisdictions. That's not to say that it doesn't come with risk. And the purpose of today, and it's a great question because it highlights some of those principles. Now, if you are the person who is engaging with those suppliers and maintaining that market contact, you need to think about, well, what's my role going to be in future procurements? And if I'm going to be a decision maker in those future procurements, then I'm necessarily going to have potentially a perceived conflict of interest issue. Right? And you can do that with your eyes wide open. So that's sort of principle number one. The other principle is, well, if I'm engaging with these suppliers and I'm maintaining contact, what information am I going to share with them? Because, they'll meet with me and they'll give me information, but, questions either come People are going to inquire as to, well, what's the department going to do in regard to this, this and this, and when will those bids be coming out? And that type of information, you need to be conscious about what it is you're going to share and whether the rest of the market, when the time comes, needs to be provided with that same information. So, look, my recommendation is do it. Do go through the engagement, but structure the process. Have it designed to meet some of these risks. And that might be, look, I don't go by myself. I take someone else from the department, so I've always got someone else there who's a colleague who can attest to what was said or not said. We can do it under a semi-organised arrangement where, I'm making it clear to people that I'm meeting with a number of suppliers. You can have some notes of what we discussed. And when the time comes, as I said, where you're declaring your conflicts of interest, you make sure that as part of the process you declare to anyone who's running that process those contacts you have had and the information you've shared. That, from an accountability perspective, will put you on the very best footing to defend any claim of unfairness or bias or an allegation that you're operating with a conflict.
Thanks, Jamie. Another question we received on a similar vein, but maybe more specific, is how can the public sector conduct more sophisticated procurement, such as category management, whilst maintaining probity obligations? That is, engaging in strategic relationships with critical suppliers which appear to run counter to the obligation for open and competitive procurement.
Designed industry engagement programs. Again, best case scenario, put some definition around it, put some structure around it. If there's critical suppliers in critical industries that you need to make sure that government is staying in touch with and knowing what's going on, invite them to participate in a think tank, or different jurisdictions have different sort of models for this. But again, if you're inviting them to participate in it, put some conditions around it, put some structure around it, put some rules around it. So again, when the time comes to run a process, you're not worried about the infection that might be caused by those previous dealings. You have a clear record of what it was, you have a clear record of the terms in which it was conducted, you have good notes of who participated. The evidence, the proof that you need if a claim comes is there for you. I think government's getting better at this, and I'm seeing it, particularly in some of Victoria, New South Wales, where they are thinking more at an industry level engagement. That seems to be really effective, and by virtue of government initiating that, it actually becomes a case where government can then step away from it a little bit, and the industry itself will start feeding as a collective the type of information that government's interested in receiving from that sector, and then it becomes the market pushing you information rather than you pulling information, which is always a little bit easier for government to deal with.
Thanks, Jamie. We've got another question on probity, which I'll throw to you, which is, sorry if I can just open that. The question was really about the evaluation criteria and whether that should apply to government funding grants.
Oh, lovely question. Literally an hour or so ago, I was doing a national webinar on funding and grant agreements, and it was one of the things that I addressed in that webinar. Yeah, look, in a competitive grant arrangement, most of our grant frameworks around the country require us to have an objective basis for assessing, one, an application received in relation to grant funding, and to support any recommendation for the funding. So in circumstances where it might be the minister who's making the ultimate decision based on a particular statutory regime, a recommendation might still have to be made to the minister into who should get the funding and who shouldn't get the funding. Evaluation criteria are just a simple way of demonstrating objectivity. Long and the short of it, it's the way of saying to people everyone has been treated fairly in accordance with what the agency identified as being valuable to it. Right, so there's no magic set of evaluation criteria. There's no one size fits all. There's common ones that we use, price, experience, expertise, blah, blah, blah. But really, as part of setting up your process, and it goes back to that comment I made about, don't just have a probity plan, have a process plan. That consideration of what the criteria should be should actually align with what the things are that the agency most values in terms of delivering the outcome. And that's as true for a procurement as it is for a funding agreement. You might want a supplier under a funding agreement to be able to deliver the objective or deliver the activity in a particular sector. Or you want, a funding recipient who's got a demonstrated history potentially of delivering in that particular sector. So, the criteria become the easy measure, the easy way in which you demonstrate objectivity. And so for any competitive grant process where you're going to the market and saying, everyone's or a cohort of the market is able to apply for grant funding, my recommendation is yes, you should have evaluation criteria, you should have an evaluation plan, you should treat it much like you do a procurement evaluation.
Thanks, Jamie. We've got another question which says the current State Supply Act doesn't extend to GTEs. Does the new Procurement Bill definition of agency extend to GTEs? In short, the answer is no. They're expressly excluded by the proposed bill. So any body corporates established under the Electricity Corporation Act, all the ports under the Port Authorities Act, the Water Corp and the agency established under the West Australian Land Authority Act are all excluded from operation of the new procurement bill.
Donna, can I make an observation just nationally? Interestingly, because a lot of the similar procurement regimes nationally which exclude GBEs or government-owned corporations from the application of the rules themselves. My experience nationally is that a lot of the GBEs or the government-owned corporations actually internally elect to follow those rules and procedures as a matter of their own corporate governance. And again, the history of things, certainly my experience and the reasons why a lot of the GBEs have said to me they've done it, is they've said it just makes it easier because a lot of the market don't necessarily always understand the strict distinction between whether you're bound or you're not bound. And so they come with an expectation of the procurement being done in a particular way, and that expectation is that it'll follow the same sort of procedure and policy under the relevant procurement directions. So while the GBEs aren't caught, as Donna said, you may find that as a matter of corporate governance, a lot of them might elect to adopt compliance with them as a matter of course.
Thanks, Jamie. The next question is, have any procurement directions under the new legislation been released? In short, no, they haven't. We can probably guess what some of those procurement directions will look like based on what's happened in other jurisdictions, but no, for the moment they haven't. I'll go to the next question. I can click off it. Have you noticed any trend about industry willingness to comply with laws generally? I've noticed that the need for speed in construction projects has reduced an appetite to be compliant and a corresponding lack of respect for probity. Jamie, this is probably something more national, but... but
yeah, no. I mean, I think it goes hand in hand, I suppose, with the drivers for a lot of those projects, which are obviously cost and time. And contractors, if you ask them the question and said, are you deliberately seeking ways to deliver projects which are non-compliant with the laws, their response, I suspect, quickly to you would be, well, we're only looking for those sort of shortcuts because you've got such aggressive timeframes and you're pushing us on price. So, you know, I think it's symptomatic of the environment in which we're delivering lots of procurement at the moment, where compliance levels haven't reduced. If anything, you know, post the banking inquiry, it's a great thing if anyone is students of regulation. The Banking Royal Commission is a wonderful case study in how a sectoral inquiry can affect regulation across industry. Because what happened is the banking inquiry, obviously a number of regulators were caught a bit of asleep at the wheel. And so every other regulator in Australia has basically woken up and now has considered what sort of additional regulation and compliance they need for the proper administration or oversight of their industry. And so what we've seen in the last 3 years is, if anything, additional regulation in key areas. Health and safety has always been a huge one, continuing to be an area of intense review and compliance for organisations. But there's a lot of other areas as well now. Modern slavery compliance, you've got, I'll call it the social service areas of compliance, which are being pushed onto tenderers. So, you know, if you're looking at it through a tenderer's perspective, the book of compliance has got much larger in the last 3 years, yet there hasn't really been an equal change to the types of timeframes and price that we're willing to pay for the delivery of those particular types of procurements.
Thanks, Jamie. I'm conscious of the time. We've got about 3 minutes left. There is one interesting question which asks, have you got any tips for dealing with appointing consultants, including existing incumbents, and the perception that the incumbents are treated more favourably? Yeah, look, I've lots of tips on that. I mean, the best thing to do is get it when you start the consultancy engagement. If you can deal with the issue before the consultant's actually embedded, it's much easier. And so that's looking at your standard consultancy engagement terms and having provisions in there which allow you, for example, to identify specified personnel, have provisions that will ensure that those specified personnel are restricted in circumstances where, you know, the organisation wants to participate as a bidder in a consortium or otherwise in response to a tender. And then having your information management protocols all sorted. So, for example, you know, they used to be called Chinese walls, now they're called information barriers. Having an arrangement with a consultant up front to say, tell us how you're going to mitigate the risk of information that these specified personnel who are working for us will feed that information back through your organisation and onto partners of yours who you might be bidding with. That protocol needs to be established upfront. You need to be satisfied with it and tied away for it to be defensible. Thanks, Jamie. In the interest of time, that I think concludes the questions. We'll try and respond to those that have asked questions outside the webinar. Thank you so much for everyone who has joined us online today. We hope the information was practical and that you've got a better understanding of both probity fundamentals and the new procurement regime that's being introduced into Western Australia. We would love to hear your feedback on today's session, and we'll be sending out a survey. That is your opportunity to also let us know if there's other areas of interest where you would like to drive the conversation for future webinars. Again, thank you for attending. We'll see you at the next session, and stay safe and stay well. Thank you.